So good afternoon, everyone. For those of you who don't know me, my name is Peter Crane. I happen, among other things for this town, I am chair of the Ad Hoc By-law Committee, which is responsible for this presentation today. We're here to start talking about all the changes to all the bylaws that this committee is proposing at town meeting on February 15th. That's a week from Thursday. Snow is scheduled for Monday and Tuesday so far, but it's too early to trust it. We're hoping it's good weather. We have a lot of bylaws. This session will begin at the beginning. I actually have a presentation to talk about things, and then we'll get into the review of things that are changing. And we get as far as we get, and next week we pick up where we left off and we continue. And hopefully finish next week, because next week is the last opportunity for this before town meeting. I thought I would do a little differently and let us do, because there are faces, people I don't know, thought we'd do once around the room. There aren't very many of us, so we'll start here.
Anita Carlson, and I know everybody.
I bet you do. If you don't mind introducing yourself, if you don't want to, that's fine also.
Karen Norwald.
Gail Price.
Dick Price.
Todd Robbins and my wife Karen Healy will be here in a couple minutes.
Okay, looks like
I see
maybe
somebody.
even other people are showing up, but I don't know if that's for us.
I saw somebody, but I don't think it was Karen, so.
Yeah, she wouldn't quite be here yet. Oh, yep.
See, nice weather and more people come out.
That's right, people show up when it's not 5 inches of snow and fighting it while we're driving.
They were here last week.
Yes, they were. So we've sort of just done a once around the room to introduce ourselves, just to give names, and I don't know you, so would you please introduce yourself to me?
Sure. I'm Mary Clark.
Richard Clark.
And Richard Clark.
Longtime AC, animal control.
Animal control officer. I remember him saying that to me last week. All right, do you need either
Oh, yeah, I didn't.
No,
handout? This is a brand new published yesterday version of the
Oh,
same
alright, well,
document, but we got,
Take that.
we'll
Thank
talk
you.
about
Another
it. Would you
new
like
one.
those also? You will actually see very small differences between the paper version of the presentation and what I'm gonna present, because I've been updating it as we move along. So let's see. Oh no, first I need to share. Which means first I need to make everything work right. Share that. Get that over there out of the way, and yeah. 5. There we go. A town has two kinds of bylaws. General bylaws, which are for most things in the town, and zoning bylaws, which deal with land use. We're gonna discuss general bylaws, which is everything except land use. There's always a little asterisk in everything that I say, because there are details. Sometimes there's land usage in the general bylaws, but in general, land use is set aside to, is set aside to zoning. We'll talk a little bit about history of bylaws in the town, not very much. I'm not trying to put everybody to sleep. We're gonna talk a bit about the committee, where we are, how we're moving forward, and then we're going to get into consequential changes review, and I will describe what that means as part of the presentation. From 1732 until 1895, there were no bylaws in the town. In 1895, the town decided it needed to have a bylaw dealing with truant scholars, what I love to call the hot button issue of the day. And it was that way until 1904, when two more bylaws were passed. One dealing with, as it says here, government structure and processes. And another one dealing with public decency, posting bills, constables, and yet another hot button issue of the day, frightening horses. I'm not trying to minimize that. But there's not a lot of value today to a bylaw about frightening horses, all other things being equal. Then in 1940, the town had formed a committee through town meeting to study and develop a list of bylaws for the town. They've repealed those 3, and they put in place the 6 bylaws that I have listed here. That book was about 12 pages long, 4 by 5 or so. And ever since then, the town has added and changed and repealed bylaws as the town saw what was necessary, based usually upon a situation that somebody says, we can't let that happen, or we have to prevent that. Or Mass General Law was changed in a way that allowed us to write bylaws. We've grown to 35 bylaws. It has no structure or organization whatsoever. This is the version of the book from 1979, which is 18 pages long, but is actually a cheat because it doesn't have the earth removal bylaw in it that had been passed a couple years earlier. November 2015. (2019). And then something that's pretty close to what we're proposing. These 2 look to be about the same thickness. Single-sided, double-sided. Now, a lot of that has to do with formatting. Having a single consistent font, a single set of presentation, as I like to call it. So, in 2017, the Ad Hoc By-law Committee was formed. Its function was to codify, to make a consistent presentation, look and feel to all the bylaws. We were also charged explicitly with creating a bylaw to create a permanent bylaw committee to replace this Ad Hoc By-law Committee, which we did and was adopted at 2019 annual town meeting. Our original charge expected us to be finished in 2019 annual town meeting. Since we're here today in 2024, you can be pretty sure that did not happen. Why not? There were problems. Some laws out and out conflict with Mass General Law, which they are not allowed to do. Mass General Law always trumps anything that's written in our bylaws. In addition, not only has Mass General Law been explicitly changed, court cases, what the lawyers call case law, implicitly change the import, the utility, the usefulness, and the application of specific laws. And how those court cases go impact Mass General Law and our bylaws implicitly. A number of the bylaws that we have today conflict with how we actually do business. In addition, these are all codification things. There's never been an organization. We just have strings of bylaws. There's never been a consistent structure or style. You open 2 bylaws, they look radically different. They not only were they not done by the same people, that's not surprising over 80 years, but no one ever tried to apply a single consistent style to it. And one of the things I find really interesting is if you were to go to the town clerk and ask for a copy of the bylaws, you get something that looks like this. But if you look at it online, they look different. And if you look at the old website versus the new website, they don't look the same. Those are all problems we decided need to be fixed as part of what we're doing. As a result, the Ad Hoc By-law Committee asked the Select Board to change our charge. So the first one is fairly well what it was before, make a consistent format and presentation. Then change the bylaws so that we are consistent with Mass General Law, we are consistent with case law, and we are consistent with what we do in town today. We are preparing the body of bylaws for a future town meeting, and then we hold these information sessions to inform people about what's going on. In general, the review process goes like this. We work on the bylaw. We look at the current bylaw, we read the Mass General Law that backs it up, or the case law, whatever. We propose a series of changes, sometimes by ourselves, sometimes with SMEs, subject matter experts. The police, the DPW, the fire department, the town clerk, whoever is responsible for it, that we consider them the subject matter expert, and sometimes we work in isolation and give it to them afterwards, sometimes we work together, and there's an approval process that goes through that. Once the subject matter experts are okay, it moves on to select board review, because the select board has to place the law, any amendment, on the warrant. So if they don't agree, they're going to object, and we'll have a problem. So there's a select board review. After that is legal review. Anything along that way can cause changes significant enough to go back through the review process. Happily, legal review, which is finished Thursday this past week, hasn't exposed anything that needed a lot of other reviews. The output of legal review goes to public information session like this. Now you'll notice there's no arrow back. Town meeting's in 10 days, roughly, 11 days. We don't have time to make changes and get it through the review process because, among other things, the warrant has been posted. So it's too late to change what is being proposed at town meeting, which does not mean that nothing can change, but what goes into town meeting is fixed. And finally, obviously, February 15, town meeting. I thought I might take a little time to talk about what happens with the bylaw and how it actually goes from creating an idea to actually being enacted. So in this case, the Ad Hoc By-law Committee is proposing a bylaw amendment, whether we're doing some news, some changes, and some repeals. A lot of changes, a couple new, a couple repeals. This is also what we call the happy path. If any of these don't work, the process stops cold. So we proposed to the select board to put the amendments on the town meeting warrant, which they have done. Town meeting, we will debate, discuss, and decide whether or not to adopt these amendments. Assuming that they get adopted, the town clerk has 30 days to create a package for the Attorney General's office to review the bylaw. Every bylaw amendment is always reviewed by the Attorney General's office. The Attorney General's office then can say, good to go. You're good, but we have a few comments. You're good, but we're going to reject these portions. They'll explain why in law. Or, the worst possible case, no, we reject this entire amendment. And this town has seen all of those in time. The Attorney General's office gives comments back to the town clerk, who then sometimes have to tweak the bylaw, because if the Attorney General's office says, get rid of this section, it gets removed. And then there is a posting that says these bylaws have been accepted by the Attorney General's office. And then, at that moment, a general bylaw becomes effective. It's not effective when the town passes it. It's not effective when the Attorney General returns it. It's not effective until the posting is done. If you do the math, that's 4 months. February, March, April, May, June. Anything that's adopted by the town on February 15th won't become effective until June-ish. Could it be faster? The Attorney General's office does not have a history of reviewing things really, really quickly. Fine. And we are passing a massive amount of information to the Attorney General's office. Do I think they'll take longer than 90 days? Wouldn't surprise me at all.
I think by law, they have to, unless our packet isn't complete.
It isn't complete, right.
And they're usually right on the mark. And I did sit at lunch the other day with the three women that are in the AG's office. It's actually in Worcester, and they review them from all across the state. And I gave them a heads up that this is coming their way, so.
And also, it's a slow time of year for the AG's office. a small differentiation, a general bylaw becomes effective when posted. There's a weird thing with zoning bylaw. Zoning bylaw actually becomes effective on the date it's passed by at the town, as long as the Attorney General's office doesn't object. So it's in a really weirdo state for 3 to 4 months until the AG's office blesses it, and then it's still effective back there. Now, the date of effectivity is very important for zoning because that impacts building and subdivisions and all of that. We're not gonna get into that more today, but just to let you know, there are differences.
If the Attorney General gives us any changes, would you, that aren't major, would you denote those when you post them?
Usually the posting is really brief and then, I can say, you know, that with some minor changes, and then I also say, you can come into our office to see.
Because we don't usually
Right.
have this many, I just figured in case.
Right.
Perfect.
So I will actually discuss that in a little bit. What did we do? It's actually the second thing we did was to create an organization. We created 8 chapters of bylaws. I'm not gonna read this to you. I assume you're all able to read this. There's nothing magical or mystical about it. It's just how we decided to organize the laws. I will mention that it's not that unusual for some bylaws to fit into different chapters. CIPC, the Capital Improvement Planning Committee, so I'm gonna pick on somebody else for a change. They are a multi-member body of the town. They are a committee. But they are involved in the financial aspects of that town. That body could live in either chapter. We decided to put the committees that deal with finances in the financial affairs chapter, so we care more about what someone does than what the body is. I said that was the second thing. The first thing we did was come up with a font, a single standardized font, and a single standardized method for identifying what we are now calling articles. Bylaw and article are words that are interchangeable in our setup. Every article has a chapter into which it belongs. This is chapter 1, general provisions. Article 1, also called general provisions. Yes, it could be confusing in some contexts. And from there we have sections. Section 1 is always, in every single bylaw, a purpose. Why is this law being written? Chapter 2, authority. Hey Dick, come on in, take a seat, get some coffee, get some snacks. Chapter 2 is always authority, and the authority in this case answers a single question. What allows the town to write this bylaw? We can't write every bylaw we might want to write. There are limits to what we can write based upon the general laws of Massachusetts. So we will always have an authority that says the general laws, chapter 40, section 21, allows us to write this bylaw. And by the way, so does Article 89 of the Massachusetts Constitution, which is the Home Rule petition. 4021 is used a lot. Article 89 is used a fair amount, but not as much as it used to be. But there are other laws that are enabled by specific sections. If you go through them, you'll see that. Some bylaws create or use specific meanings for words, so we need to define those. So when there are definitions, section 3 will always be definitions in every bylaw that uses them. If they don't have any special definitions, they go straight into the body of the meat of the bylaw, if you will. And if it does, then section 4 begins the meat. Every single bylaw, we are putting at the bottom of the very last page of every bylaw, its history. So we don't need to go through the process Town clerk and I have been looking through our old minutes for town meeting and the warrant articles to see what was done. We'll have it documented for everyone to see. Where are we? This is one of the changes. Everything is through legal review. We're no longer waiting for any more feedback. Also, there are 4 bylaws that the Ad Hoc By-law Committee is not proposing any changes to. Earth removal. The Earthworks Board is working on a new bylaw for that, so there's not a lot of value to the Ad Hoc By-law Committee going through that and making it nicer and conformant. Signs. Gigantic bylaw. Frankly, we ran out of time. And we didn't want to hold up the process for signs. Door-to-door solicitation, peddling, and fingerprint-based criminal record background checks. The committee had worked through these changes, or worked through a series of changes to these bylaws. And in fact, we were going to repeal fingerprint-based criminal record background checks and incorporate portions of that into door-to-door solicitation and peddling. We sent that off to legal review, and town council's response was, here's a model bylaw you should think about using instead of doing what you do. Model bylaw is exactly what it sounds like. Somebody came up with a standard bylaw that most places just use. When town council says, you start again, it means no. Now, I said earlier that some of our bylaws conflict with the Mass General laws or conflict with case law, and I'm actually frightened silly about both of those with door-to-door solicitation and peddling and the criminal record background checks bylaw. Because we are not amending them at all, they don't go through they didn't get town council review, well, once they said for the last 2. But that means the AG's office doesn't review them. Because the AG's office won't review them, the AG's office won't say, bad bylaw. We've already gotten comments on previous versions, but they're even more strict now than they were when they were initially passed. So this Ad Hoc By-law Committee will not be working on those. The intent is to transition all the work that remains to the Permanent By-law Committee, which has been advertised. If anybody's interested, please send a letter to the Select Board. Now, there's a little bit of a hitch. Those of you who were paying enough attention know that we tried to put bylaws on town meeting, not last annual, but the previous November. And at the very last minute, as legal was reviewing everything, and I was having a heart-to-heart with town council, and town council says, wait, you need special legislation. Blah? Special legislation is an act of the Massachusetts legislature that supersedes Mass General law. And that's what we require. We require it for 2 purposes. Town meeting in 2007 voted to increase the size of the select board from 3 to 5 people. There was supposed to be special legislation there. In 1974, when the town voted to get rid of the water commissioners and sewer commissioners and to enact the Board of Public Works, well, that's fine, except that the town also voted to make the select board act as the Board of Public Works. That requires special legislation. Just over a year ago, we met with Representative Ferguson and Senator Goby, who is no longer a senator, as I'm sure we're aware, and they co-sponsored S-2371, the official designation of our special legislation to do this work. Both houses have already passed it. It's waiting to be engrossed, which is the fancy way of saying bundled up into a bunch of laws that are all sent at once to the governor to be signed. Unfortunately, that law doesn't become effective until it's signed by the governor. So we're in kind of a race here. We have a few months of play, but not as much as I would like. As far as the Attorney General's office is concerned, there are two kinds of changes. There are editorial changes and there are substantive changes. Editorial changes. We spelled that word wrong. And it's obviously the wrong word. We misspelled commercial. Having just typed that recently, I know that that's one of the examples. We're allowed to, the town clerk is allowed to change things like that anytime. If the town clerk wants to change the structure of the organization, the section numbering, any of that, allowed to do that. Along with what we call editorial text. Footnotes and the bylaw history are not formally part of the law. They're just extra information. So that can be changed anytime. Any editorial change can be made at any time and does not need town meeting approval. Everything else is a substantive change. If you say, I don't like this word, I like that word. They missed a comma, or there's too many commas. Any punctuation change is a substantive change, and every substantive change must be approved by town meeting. The vast majority of changes proposed by the committee are substantive changes, virtually all of them. But not all of them are big important changes. If we change a word, who cares? If we split this long 6-sentence paragraph into 6 sections, that's a substantive change. But it's not important if we don't change the words. We created the concept of a consequential change. Consequential changes, anything that affects the intent or effect of a bylaw. I have a somewhat trivial example. We are proposing town meeting quorum be changed from 10 voters to 30 voters, meaning that we intend that there should be actual voters, actual residents at town meeting, not just the select board, the finance committee, the moderator, the town clerk. Today, just having those people together means that there is quorum for the meeting. There's a separate document in your hands which describes, but does not list every issue or each thing, but that document tries to describe these consequential changes. If you want to get detailed history, look at the bottom of any bylaw. It lays it out. There are long paragraphs of changes because of all the structural changes that we made to so many of the bylaws. Questions on that so far? We know these bylaws aren't perfect. We knew we weren't going to create perfect bylaws. And not just because I personally don't believe in the human attainment of perfection. Beyond the fact that we're all humans, there are different ways to look at the bylaws. Our belief and our charge to change the bylaws according to current town practices means we try to answer the question, how does the town behave now? What do we do? How do we act? The town is traveling a road of transformation. We're in the middle of a lot of change. It started a long time ago and it's going to keep going for a while. We did not try to answer, how should the town act? How should the town behave? That's a much bigger, much deeper conversation. Much better answered by a charter committee and the permanent bylaw committee, but not the ad hoc bylaw committee. So questions like that do need to be answered. Somebody needs to have a plan for the town, but this ad hoc bylaw committee are not the right people to do that. In addition, I'm not saying you have to just take it or not, but generally, passing only a portion of bylaws can create conflict. If you say, we're going to adopt the new town administrator bylaw, but not adopt the new a select board bylaw, you are going to create conflicts. There's a lot of interaction among especially the governmental bylaws. I believe in the metaphor of a building, that the bylaws are not completely dissimilar to a building, in that chapter 1, the footings, the base. Without that, there's nothing to set anything upon. And chapter 2 is what I liken to the foundation. Okay, you got something solid, now we build load-bearing walls. That's chapters 3 to 5, which is the rest of government. And then chapters 6 through 8 are the roof and the interior walls and the finishes. It's not a perfect analogy, I know that, but just, if we don't have a good chapter 1, we can't have a good foundation in chapter 2. And if we don't have a good foundation, we can't have a good section. The rest of government is going to be more questionable. Yeah, that's all I want to say about that. Everything that we've done, current status is on the website. These snapshots are now old, but basically, boards and commissions, the Ad Hoc By-law Committee, way over here is proposed bylaw updates, which brings you to a page that says a lot of everything I have just said. The through date, if you were to go right there right now, says yesterday, because I was there yesterday doing final updates. 2 important links. I think they are important anyway. 1 document with all the bylaws, just the bylaw text. Somebody wants to print it off, it's 148 pages at last check. But there's a separate document which you have, which is the list of consequential changes. It is my understanding that the plan is that the list of consequential changes will be the handout at town meeting. Because anybody's going to try to go through 148 pages on the floor to look for issues. I'm sorry, it's too late. A little further down the page, every single bylaw listed by article and, well, by chapter and article, and the names, and their status. Every one of these now says complete in the legal review column, because they're all done. We happen to see revolving funds, which isn't getting amended at this town meeting, because it was amended May 6, 2023. We aren't making any changes to that, it's already been done. A little further down still, something I wish there was a better way to do, but the old version, or the current version, the new version. I couldn't find a way to open them up side by side. So it's going to open 2 windows that you can arrange side by side if you want to try to read them that way. I don't recommend that, having gone through every one of them like that in order to come up with a list of changes for the bylaw history. It's not fun, but if that's what you would like to do, please feel free. Questions before we continue to the review? Nope. We have a quorum.
And not so much a question, but
Yes.
I understand the difficulty in how you all made the changes and put things in different sections. So it is difficult to review side by side. We did similar with school committee. The problem I have is not seeing some kind of red line version of this so that we can see what was. I understand we have the paper with the changes, but it doesn't explain anything. It doesn't let you see what is being changed with the old. And it's very difficult to comprehend why these changes were made. So I do understand some of it is MGL, and that's kind of a given for me, right? Of course we have to approve that. So if on this sheet you had, highlighted in yellow, everything that is a required change by MGL, that would have been very easy for me to say, of course, we have to do that. Or this is current practice, just something to say why. I understand this is hours and hours and days and meetings and meetings and meetings. Impossible for me to watch them all. But having that explanation would have made this so much easier for the public to understand why it was being done. So maybe for the future bylaw committee, moving forward, if they can do something like that, I would appreciate it.
Thank you, and I'm not gonna say you're wrong. I will say, one of the reasons this whole process took so long is because the town has been suffering with 80 years of neglect of the bylaws. Had somebody done this 40 years ago, it would have been about half as painful. And it would have been much easier today. In fact, well, it would have been easier. And different, everything's different because everything changes in time. Red lines are virtually impossible to read. I mean, in fact, I tried to pull them up, the red line, and I couldn't figure out how to configure a word to make it show the red line version. I can show you. Let me just pull up this for the sake of pulling up something. Fortunately, the deletions are pulled over into a separate area, but we pulled out, deleted, we added this. The colors are wildly inconsistent thanks to Word, so you can't tell who types it just based on the color. So, going see, like, here's some text in another color. Why? Because somebody else added that. Why? Doesn't matter. As I say, and if this had been a pure red line version, it is illegible. Well, excuse me, unreadable. Now, classifying the sets of changes, that's a very interesting idea. Certainly worth considering for the permanent bylaw committee.
I mean, the consequential versus not consequential.
Yes.
The consequences, it could be consequential to residents or consequential to this committee versus that committee, consequential, one committee's gonna have more power now, you know, the whole,
That's right. So we tried to write this document abstract from any given perspective, so that anything that changes any impact of the bylaw should be in this list. Now, it's not my intent to run through the text of every bylaw. That's going to be much longer than a couple hours today and a couple hours next week. So we're going to run through the consequential changes document, and when necessary, I'll pull up the text of the bylaw. And what I'm going to do is actually first pull up added definitions that apply to all general bylaws. This is a big change. There are some words that are used so frequently in the bylaws that need to be defined once rather than every single bylaw that uses them. Where are you? We have boards, we have committees, we have commissions, we have a council. They're all multi-member bodies, and we decided to use the word committee as a generic term for any any appointed multi-member body of the town. So the Conservation Commission, the Council on Aging, but not the Planning Board, because the Planning Board is elected, not appointed. So anywhere where you see the word committee, unless it's referring to the committee in a particular bylaw, we mean it applies to all the appointed boards, multi-member bodies. Now there are days, I'm just gonna go to the bottom, and as it says, the day is a calendar day. Then we have a working day, which is no Saturdays, no Sundays, no holidays recognized by the town. When a bylaw says something has to happen in 3 days, and that's all that it says, do they mean 3 days, including the weekend? So you deliver it on Friday and something's due Monday? There's a lot of not reasonable about that, we think. If you see the words working day, we mean those 5 days of the week minus the holidays. And if you don't see any adjective before day, it's a calendar day. Licensing authority is anybody who can grant licenses, okay. Whether it's a department, a committee, a singular town official. And a town official, by the way, is anybody who's involved in the town, basically. Town officer, employee, or member of a committee. Committee is not capitalized, it's not a committee, it's any committee, so it's any multi-member body, whether elected or appointed. They're all town officials. They all have the ability to act on behalf of the town. So these definitions apply to every single bylaw. I'm just gonna step down a little bit. Blah, 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 yeah, severability. The notion of severability, yes, Dick?
Your working days.
Yep.
Fridays, is some of the committees or people working on Friday?
Yep.
But not all.
Any of them may. The town clerk's office
We know.
has people
that.
in it on Friday. Because Friday is still a working day. It's just not generally open to the public, which is a different question.
That's it, right there, okay. Thank you.
In our current general bylaws, some bylaws have a severability provision and some do not. Severability is the ability to strip out one portion. If the town gets taken to court over a bylaw, and the court says, this section of your bylaw is not correct. Now, first of all, we have to count it as stricken from there on, but what's important is that the rest of the bylaw is still valid. Only that one thing ruled invalid is invalid. Rather than have severability in every single bylaw, we put severability here saying if any provision of any town general bylaw, regulation, or rule, yes, that includes regulations and rules, shall be held invalid by a court of competent jurisdiction, such invalidity shall not be construed. Basically, it doesn't impact the rest of the law, or the regulation, or the rule. Yes, I know it's listed up in the consequential changes document as well, but. Okay, current bylaw, general provisions bylaw says the town clerk can make editorial changes to a bylaw basically after consulting with the town administrator. There was one particular town administrator who really wanted that. But we don't see the value. We, the Ad Hoc By-law Committee, don't see the value in consultation for editorial changes with the town administrator. So we stripped that out. Former Section 2, now Section 5, is dealing with generic rules about enforcement and penalties. One of the things that we have done is to take, there's an entire bylaw today called non-criminal disposition, which is one approach to enforcing laws and assessing fines. There's criminal, there's civil, and there's non-criminal, each of which has a different path for enforcement. Non-criminal really means you can write it, that whoever enforces it can write a ticket. And humana, we get paid and everything just works. Well, those portions of non-criminal disposition were brought into the general provisions bylaw, along with everything else that talks about criminal action and civil action. Those are all still valid, but that section was substantially rewritten primarily to include non-criminal disposition. I've already mentioned this. Enforcement covers laws and regulations and rules. If there's a violation that is not covered by an explicit fine, the fine is $100. Department heads are empowered to delegate enforcement of bylaws to people in their department. So the police chief can delegate enforcement to a police officer, but can't delegate enforcement to the DPW. Every police officer is always allowed to enforce every single bylaw in the town. That's actually not a significant change. There's only a wording change that makes it very clear. But also to regulations and rules, and that's the real change here. In a previous iteration of this bylaw and legal review, there is today in general provisions the notion of a select board instead of a board of selectmen. Mass general law universally says board of selectmen. And they're not all men. So ages ago, I'd have to look to see when it was modified, but there's a provision that there's one of the components of the current general provisions bylaw is that we can refer to the select board in bylaws, and that the select board has all the powers of a board of selectmen in Mass General Law. Last time I went through legal review, they said, here are a couple of small changes. Literally a 2-word change, and otherwise. So now, there's a select board as referenced in the bylaws, and otherwise, and that means that the body is no longer called Board of Selectmen once this is adopted. It's not just the bylaws, it's any reference to Board of Selectmen can go away, it can be replaced with Select Board. Which is, by the way, a fairly common thing. A lot of towns are doing that. We're catching up with a lot of towns on this, but. We have an office called, trying to remember. There was a special act of the legislature in some decades ago now that combined what is normally 2 offices, the treasurer and the tax collector, into a single office for the town of Rutland. And they called it something like treasurer-tax collector, something like that. There was a slash, or there was something really weird going on in there. And nobody likes that obscure name in the special act, and so pretty much at Becky's request, we specifically put treasurer/collector as the name of that office in the town, and again, as otherwise. I've already covered severability. There you go. As I had said before, non-criminal disposition is going to be repealed, and the important text has already been incorporated into that first bylaw. And the fines, instead of being listed in the table in the non-criminal disposition bylaw, are distributed to the appropriate bylaws. We have a bylaw today called membership requirement that basically says, in order to serve on a committee, you need to be a registered voter of the town, which is a more strict requirement. Normally, you only need to be a resident of the town, but when was that done? Do you remember?
No.
10 years?
Maybe around that, I think.
10, 12, 15 years ago, the town passed a bylaw that said you have to be a registered voter. It's fine, there's nothing wrong with that. But the committee believes that that there should be much more strict definition about committee behavior and committee function and committee structure than is specified anywhere else. So we changed the title from membership requirement to appointed committees because these are the general rules about how committees govern. So we do this so we have a bunch of bylaws that are just about committees, and rather than say the same thing again and again and again, we put them all in this one bylaw. So unless there's something that conflicts, they're appointed by the select board, they serve without pay, each committee elects its officers and selects a clerk, terms run from the 1st of July to the appropriate 30th of June, and 5 consecutive absences make a member eligible to be removed from the committee. That last one, with a change, came out of the Finance Committee bylaw. If somebody's not serving on the committee and they don't have a good reason, then they should be removed. This can only apply to appointed committees. It can't apply to elected bodies. Now, Karen, pay close attention here, because legal review changed this. It's not removed by the committee themselves, it's removed by the removal authority.
Which in the finance committees is Randy and the selectmen.
Correct.
Because we are different than most. We are
right.
appointed by Randy,
Yep,
the town
And
moderator,
ratified,
and
yeah.
ratified by the select board.
yep. Let's suppose that a committee member, say me, pick on me. Now, it's been said the Conservation Commission is on the take. It's been said for years. It's not true, but it doesn't matter. It's been said. So suppose that I really am on the take, or suppose that I do something really bad. Today, I can't be removed from the appointed committee. There's no process for it. Even if I were thrown in jail, in the current state of the bylaw, with the new bylaw, after I miss 5 meetings, consecutive meetings, assuming I don't show up remotely, I could be removed, but that could be a long time. There is now a process for an appointed member of a multi-member body to be removed. I'm not gonna go through the details. It involves a hearing that might be public or it might be executive session. The ability to answer, the ability for the accused to have counsel represent them, all of that is in that process. There's a whole section about that. So this piece, that last bullet item just says, of the one above, if you're absent from 5 before, this may be invoked.
Does that process that you just said that Randy appoints and it's approved by the select board, is that,
Just finance committee.
but is that written in the new bylaws?
That's in the Finance Committee bylaw, yes.
It's been that way since,
As long as
I mean,
Probably,
forever.
Yep.
That one's always been the town moderator appoints.
Right, there's this whole notion about separation of executive power versus legislative power. And the town is ultimately the legislative body of the town. Hold on. I just noticed that I haven't been paying attention. Any questions about anything so far? That's the end of chapter 1. 7 more chapters to go. I'm already excited. Chapter 2, General Government. We start with town meeting. The last vestiges of honest democracy in this country of ours, I think. Starting at the top. Philosophically, when the Ad Hoc By-law Committee looked at how the town is behaving, we've noticed that for quite some time, we've had 2 meetings every year. One in the spring and one in November. And the one in the spring, the date's been fixed in law. And the one in November has never been fixed. We'll get to it when somebody sets it up. And there are some good reasons to have it be variable, but there are also some good reasons to have it be, in our opinion, that it can be planned if we set a date for that fall special town meeting. I think I need to tweak the language here, because I think council changed it to spring annual town meeting, which is the worst of all possible cases, but Mass General Law says there must be an annual town meeting, and it must be between February and the end of June. Ours is in May. We wanted to call it spring town meeting, but council said, no, it's spring annual town meeting. Fine. And I'm just gonna skip down a couple. I'm not gonna skip over it, don't worry. And then we're going to call the November meeting the fall special town meeting. And the fall special town meeting is the 3rd Thursday in November, which is guaranteed to not conflict with Thanksgiving. It's basically 1 week before Thanksgiving. That is our proposal anyway. Spring town meeting, or the annual, we are proposing gets moved from the Saturday before the town election to the Saturday following the town election. Our primary considerations for that, number one, let's do importance. Importance to me is that the amount of work that needs to be done by the town clerk's office between the election and the meeting is substantial. And that with no time in between, it has always been difficult since this change was last made. But it is more difficult when you don't have any working days, or you have actually 1 working day technically. No, it's Monday. You have 0 working days between the town meeting and the election.
It's working on a Sunday, basically.
That's right. In addition, more often than not, the day following town meeting today is Mother's Day, which gives people an excuse not to go. Well, we're gonna go out to brunch on Mother's Day and we don't wanna spend too many hours at town meeting. It gives people an excuse. So we're trying to do away with the excuse.
But in doing away with that excuse, it does, the town meeting, the annual town meeting brings about 200 people that sit in the chairs. So that if we have to bring up a 2.5 override, a debt exclusion, or other things, that's the place to get 200 people in chairs that can learn about it. They should be doing it ahead of time. I'm not saying that it excuses it, but at that point, we get 200 people in a room that can hear it and the importance of it. If you do the election before and then do the town meeting, I think you're losing the 200 people sitting in those chairs to then figure out what is the important piece. In my opinion, the 2.5 override would not have passed if we didn't have the town meeting before the election.
See, I don't know that I agree with you on that assertion, simply because we had sufficient turnout at the information sessions each of the Sundays in advance, and I believe between that and all the other communications efforts that took place, and I'm not gonna try and list them all, there were a lot of communication that went out about it. I think that the town figured out a way to communicate that information exclusive of town meeting.
Did we have more people vote in that election than we usually do?
Well, I think some of it might have been because there was like vote by mail.
Okay, but we had, good, that's the only thing I'm saying. In my humble opinion, I think that we got people to come to those town information sessions, but I think those folks would have voted anyway. I think we got 200 people that maybe wouldn't have voted, or a significant bunch of people who necessarily wouldn't have thought so much to come and vote if they didn't hear what we had told them at the town meeting. That's how we've passed debt exclusions in the past. That's, I mean, 9,000 people in the town, and that's our best spot to get those people sitting in a room to realize the importance of the reason why you have to go out and vote.
So to that point, is there a reason that it's the following Saturday rather than the previous Saturday?
Getting town meeting moved earlier is a bigger problem because of the information that's necessary.
Yep.
Really, it turns in, you gotta have everything for the budget done, and our budget process is always tardier than we like, simply because we don't get all the information that we need from all the other bodies that deliver us information, the state, the different school districts, anybody. We get lots of information from a lot of sources, and they don't come in early enough for us.
Insurance.
Insurance, that's right. There's a lot that we need to actually formalize and complete a budget.
So I know we have always said
And
that.
actually, excuse me, I just wanna say one other thing. One of the things we considered was moving it a couple of weeks later or into June, but then we ran into different scheduling problems. So we,
Peter,
Yep.
if anybody's wondering why we don't move the date of the election, it's primarily because all 5 towns in the Wachusett region have their elections on the same Monday that we do, and that allows us to use the schools without, most of the time, use the schools without the kids being present, so.
Is that gonna be the case going forward? Cause last year they
I know.
were open.
I
So
know.
that's the thing. I'm looking at it going, why couldn't we just move the election to make it easier on the town administrator, at the town clerk's office, excuse me?
and again,
Because with the schools were open last year, they're open, are they open for the? Cause I go after work, I don't know, were they open for the presidential elections?
You mean,
When we have the presidential elections in November, are the schools open?
no, they were closed.
They are closed.
The only time, in the past, it's only been like the primaries, which, that they stayed open, stayed closed.
So I can't-
Opened, but
I
not-
can't speak for what would happen in the
Yeah.
future, but in the past, so the way the schools close for these election days is that the teachers use their professional development days on those days, and they schedule them accordingly. It's difficult to just say, oh, well, professional development makes a whole lot of sense to do in May, when really we need, for example, we're rolling out a new curriculum, and that day would be much better spent by the teachers in September or October, when they could, have a better understanding of the curriculum, rather than a full day in May. So to just say overall that is definitely gonna be a thing, I don't think is something that could be said.
in fact, I remember seeing a recent, well, not that recent, but I have seen school committee meetings where the decision to keep the schools open or closed on election days has been a topic of discussion. I am only imagine it will be again.
I agree.
Well, for professional development too, everybody's kind of looking to where they're gonna get their professional development credits. And they might wanna go to a particular training in Boston somewhere, is that kind of, so if you only have a few days, are those floating days? Can you take those when you want?
I'm not sure exactly how it works if you have a specific thing, but they do guarantee the teachers a certain amount of professional development, and those are the scheduled days.
Oh, okay.
I'm the first to admit that our proposal to change town meeting date is controversial. I admit that it is a balancing act among a number of different considerations. It was the committee's opinion that we should move it to the Saturday, from the Saturday before to the Saturday after town election.
And if anybody in this room remembers, when Mr. Bracebridge brought it up, it was because at the time, we didn't have a town administrator. And when the budget was developed at that point, it was done with the selectmen and the finance committee. And you'd have changes once the election happened with the select board. So when questions came from the floor to the selectmen, it was, I don't know, I wasn't there. I don't know, I wasn't there. And so that was the purpose. Now, I granted, we have a town administrator now. However, as we go through the future changes, there will be some changes that, in like this past year, we had 3 brand-new selectmen come in. That could potentially be a problem. It doesn't happen often, but it does.
It happens very rarely, and do you wanna write a bylaw for the 90% of the, or the 10%? I mean,
But
that's,
even two
again,
people-
it's conflicting.
But even changing 2 people on a board can change greatly which way it goes.
It absolutely could, and I would expect that even if they were no longer select board members, they would have the ability to get up and speak. So let's just take this past annual election where we turned over 3 seats. If the select board desire for a warrant article was those 3 people, there wouldn't be anyone on the select board to speak for it anyway.
I was thinking more of the budgetary purposes.
Well, budgetary is fundamentally out of the hands of the select board now, as a practical matter. I mean, yes, they're responsible for it, but come on.
Okay.
Any other questions or comments about the date of town meeting? By Mass General Law, town meeting must be held within the geographic limits of the town unless we have a bylaw that allows something else. Well, we are about to have the ability, or we are proposing a mechanism to move town meeting out of town under exceptional circumstances. We think, for example, that there's an element of there's something on the warrant that is going to have so much opinion that there'll be more people than can fit in the gymnasium at Glenwood. What do we do? Well, now, you may remember a couple years ago that we held town meeting at Wachusett. And that could only happen because of the special legislation around COVID measures. That's the only reason we were allowed to meet outside the geographic limits of the town. COVID emergencies long over, which means that we need a bylaw to enable us to move it. And the wording is it can be in any adjacent town. So we're not gonna move it to Worcester. We're not gonna move it to Ashburnham. We can move it to Quabbin now.
You're not gonna try and define exceptional, right?
No.
Yeah, sky's the limit, yeah.
I would hate to put in bylaw if the 2 schools burn down, you know. As an example. No, I would not try to do it. it should be obvious to those, to everyone, what is something exceptional. The posting of the town meeting warrant, now with this change where it's allowed to be on the website as one posting location. There, by law, it has to be posted in 5 public locations. Basically, we're making the town website as our 6th location. We are not suggesting not posting it somewhere. I've already briefly talked about changing quorum from 10 to 30. Several town meetings ago, something about Robert's Rules of Order was brought up. To my knowledge, the town has never operated town meeting by Robert's Rules of Order. It's always, at least certainly within my time in town, it's always been town meeting time. But now we're specifying it in the bylaw. So a new town moderator can't just change the rules of town meeting. There is in the current CIPC, Capital Improvement Planning Committee bylaw, something that says you're not allowed, town meeting's not allowed to take action on any warrant article proposing a capital expenditure unless that expenditure has been considered by CIPC. The CIPC bylaw is a really, really bad place to put that provision. So we moved that provision from CIPC into this one. To be clear, for a committee to consider means not just be on an agenda, not just discuss it, but decide whether or not you're going to support it. That is considered in the law. Someone who makes a floor motion. That motion must be given to the town clerk. What we have clarified is that it must be given to the town clerk before voting on the motion. The main motions for each article are already given to the town clerk in advance. She has the motions document prepared by the town administrator and staff. But everything else, every motion has to be in writing no matter what. The current bylaw is not clear on when that writing needs to be delivered. The last few town meetings, floor motions, it's been done this way. Ever since we proposed this and Randy saw the bylaw, he's been acting this way. And it is a town moderator rule that he can say when he can make that rule. But now we're putting it in law. Currently, anyone can talk for 10 minutes on any issue. What's an issue? I don't know. Because if you have the main motion and 3 subsidiary motions to that, is the issue the whole motion? The major issues that the total time is? The only time people are allowed to talk is in response to a motion. That's debate. We're limiting everybody to 5 minutes on any motion. There's a process to allow non-voters to speak, which again has been the practice of the town for as long as I can remember. And then there is still a provision for secret ballot. Is it necessary with the new clickers? There's a huge it depends. Different people have different opinions about that, but there's no harm in having the ability to have a secret ballot.
In the town meeting body, anyone could call for a secret ballot too, so.
Are the clickers considered secret ballot?
No.
No, right, because they're numbered and their number is attached to a person.
We're not attaching anymore. We decided
Our
after
current
the last
practice
time.
does not tie those pieces of information, the identity in. But there's nothing that stops it from happening in the future.
Yeah, we couldn't tell after the fact who had a specific number or clicker. The only reason we were doing it is the clickers are pricey and we didn't want to lose any. But it also slows up the process when we're checking people in. So we've decided going forward, we're not gonna assign a number. So it just makes it easier. And hope to get them back.
Any questions on town meeting? Go for a little longer, then we'll take a break. Lots of changes to the select board. Number of members and their terms are explicitly defined in our bylaw as opposed to the way it is today, which is there was a town meeting vote that said it. And how many members are there? Well, the town meeting vote said there are 5, so now there are 5. Remember I said that CIPC thing, the CIPC had a town meeting element to it, so we moved into the town meeting. The select board responsibilities and duties had been spread throughout all of our bylaws. So the committee collected all the duties with a small asterisk. There are probably 1 or 2 that are still outstanding, but fundamentally collected all the responsibilities into the select board bylaw. So this bylaw is much longer because it lists all the duties. Most powers may be delegated. It says, but not all, because, well, it all depends on what Mass General Law says about the ability to delegate. There is currently a section dealing with procurement, which is how the town buys things. That's been removed from the select board because the select board doesn't buy a damn thing. And the town administrator is the chief procurement officer, which we'll talk about when we get to the TA bylaw. There is a current section, 3C, that talks about regulations of motorboats, which has been in there since 1955 or so. On the books today, the select board has a series of regulations about motorboats on town ponds. Except that the acts of 1960 by the legislature repealed the ability for us to have the law and repealed any regulations that were created because of it. So those regulations that exist today couldn't be enforced if we wanted to. We say quite clearly that the select board is the chief executive office of the town. There is an element, well, it actually came from a different bylaw, from the legal affairs bylaw, but says, today it says that if the town the town is sued and wants to settle, if the town has to pay more than $300, you have to go before town meeting and get approval. We changed that to $1,000. $1,000 is still a very tiny amount, but it is the opinion of everyone who we've asked that that $1,000 is an insurance cost, because the insurance actually pays when we lose a lawsuit. The town doesn't pay for that at all. So not only is the select board the CEO, they're also the agents to institute, prosecute, and defend. That is to say, if we want to sue somebody, they're the people who start that. So either they're initiating a suit or they're defending a suit. The select board are the body of the town who are responsible for that. They're responsible for the annual report, and all of those came from the previous legal affairs bylaw. FinCom bylaw says that select board has to send articles to FinCom for review, and send articles to CIPC and send articles dealing with laws to the bylaw committee. Those have all been brought into this one bylaw. And as we talked about briefly a little bit ago, the Board of Public Works is a separate body from the Select Board. In Mass General Law, they are two separate elected boards. But based on the action of the town at town meeting and S 2371 when it's signed, the Select Board acts as the Board of Public Works. Same people, same structure, but they are two bodies that have to act a little weirdly. Tomorrow night's meeting, I believe, is posted as both Select Board and Board of Public Works because they're doing something that's in the duty of the Board of Public Works and not as a duty of the Select Board. But rather than call two meetings and call it to order and adjourn and wait for the right amount of time to start the next meeting, you can do it all in one meeting, which is how it's going to be done. But they are two bodies with two different sets of responsibility. The Select Board has appointment powers to certain officers in town. For example, by Mass General Law, the Select Board appoints the Chief of Police. The Fire Chief is not so specific. That's just appointed. If Mass General Law says appointed by the Board of Selectmen, then our bylaw says the Select Board shall appoint. So we list the ones that are explicitly the Board of Selectmen or Select Board in this bylaw, and every other appointment power is in the Town Administrator bylaw. I say state removal powers there, which is a really weak statement. It's the ability to remove the town administrator. And the Select Board happens to be removal authority for any committee that's not otherwise specified for appointment. Select Board member shows up at a Conservation Commission meeting. If they're showing up as a Select Board member to speak on behalf of the board, or even for themselves, but basically to speak for the board, they should be given voice. They should be allowed the opportunity to speak at that meeting. Now, there's a process for it, but what it's saying is the chair had better have a good reason for not calling on the Select Board member if the Select Board member indicates he or she wishes to be called upon. Town administrator is allowed to take, is a full participant in any Select Board meeting, including executive sessions, small asterisk, except for those sessions dealing with the town administrator's conduct, behavior, or contract. I actually already said that. There is a process to suspend or remove the TA now. There is a ton and a half of text around all of this. Anybody who's suffering from insomnia, I invite you to read the bylaws. I think it's a good time. We take a break. Let's take 10 minutes. And we'll be back. Any question on anything we've talked about so far? I know this is scintillating, fascinating material. And I thank everyone for sticking through it. All I'll say is, you think you've been through a lot?
Now, someplace, did you, on the Ag Commission, when the town was going through one of their 61s, we felt that the town council was wrong we went to someone else. And they expressed, the council expressed, yes, they are wrong, and this is the correct way of things. And now we've been told, or I've been hearing anyways, I think that we can't do that anymore. We have to go through town council, period.
You have to go through we'll get there when we get to the town council
Okay.
bylaw.
Chapter 5,
There's a lot there.
chapter 4, excuse me.
And town administrator, I fired him almost the first day when I met him. I asked him, do you know how to milk a cow or ride a horse? No, you're fired.
Well, moving on to the town administrator bylaw. It's a brand new bylaw. We took it from, I believe, 4 different towns. I think it was 4. And no, I don't remember what they were. They're all over the Commonwealth. We also used the job description and every place else we could get information. I'm just trying to keep an eye on Sherry if she shows up. Just as the select board is the chief executive office of the town administrator is the chief administrative officer responsible for day-to-day operations. It's the chief human resources officer. I keep saying the office has very broad appointment and removal powers. Now, since we're adding removal powers throughout, we're also making sure that the TA can remove someone that the TA is allowed to appoint. Chief financial officer of the town who owns the operating capital budgets, the chief procurement officer. Now, this is actually surprisingly important. Mass General Law has this section 30B, chapter 30B, which is the General Procurement Act. And talks about the processes you have to go through to purchase something or to award a bid for services, anything. The town administrator is the chief procurement officer, and if he doesn't have training, he needs to get it.
So we had a town administrator there, an interim town administrator that did not have that. And it
Correct.
had to go to the superintendent of DPW. So what
Because-
happens in that case?
Because in that, well, it's called delegation. Because the DPW superintendent had all the 30B training and was therefore blessed as an appropriate procurement officer, that delegation authority, that the chief procurement officer duties were delegated to the DPW superintendent by the select board at that point. Because with the current bylaw, the current select board bylaw says everything they do is with respect to 30B. And so with 30B, you need a chief procurement officer, so they delegated it to the DPW superintendent for that interval. Can you find the paper that says that? I'm not gonna talk about that right now.
So that's not a requirement for a town administrator to come in with a CPO.
Correct. As long as there's someone else who can act that way. There always has to be somebody, otherwise all of your procurements stop cold. Or could be stopped cold.
And how much time did it take away from the DPW to do that job? It did.
I actually can't answer. I'm sure it was noticeable to him.
Yeah, well, yeah, I asked him and yes, it was.
Yeah. Because 30B is very, very, very process oriented. These are the steps you must follow. If you're going to do if you need something done that's going to cost up to $25,000, you have this one process. If it's between 25 and 75, it's a different, more involved process. And if it's over 75, which alas, the DPW does a lot of over $75,000 things, then it's an even much more strict process. So yes, conforming with 30B is a duty not only on the chief procurement officer, but also on the people who are doing the work, are actually doing the procurement themselves.
So does the bylaw, I'll have to go back and look. So if we hire a TA that doesn't have the procurement officer designation, does it state in there that it can be delegated to others?
Any power can be delegated at any time, basically, with very few exceptions. Any power of any body or any office can be delegated. I think the problem today would be who else in town has the 30B training, and I don't know if there is anybody else,
I don't think so.
which sounds like there's a planning and future-proofness that the town needs to take.
Succession planning?
Yeah.
I think we have some bigger ones than that, in my opinion.
Oh, without question, without question. Yeah, I mean, really, the chief procurement officer is responsible primarily for saying, the process was followed and here's the documentation that shows it was followed. But the the chief procurement officer doesn't do all the work himself.
I agree.
When I did a procurement recently, I did all of it. And I just, when I need to, I can just say, here's my file, Austin, here's everything, here's what shows that we followed the process.
But it also is that chief procurement officer to make sure that the paperwork is there.
That's right.
So that the town has all of the backup. So when that person leaves,
When somebody comes a calling looking for it.
retires, or whatever, the documentation is there.
Yep. Moving on, Chief Information Officer. TA is responsible for the administration of grants. And this is of particular interest to a specific town administrator of ours, is the main point of contact for media, the state and federal governments. Now, it's a good idea to have it, don't get me wrong, everybody should know who to go to. Now, I'm now gonna bring two things together that I've mentioned already. The town administrator has broad appointment and appointment powers. The select board must appoint, or certain officers shall be appointed by the select board, but since the select board can delegate, guess who they're gonna delegate to? Virtually everybody gets appointed by the town administrator. Select board's already delegated appointment powers for anybody they can appoint to. This year, a few meetings ago. So, broad appointment powers is even broader than the things that are said in the bylaw. I'm just pointing that out. And that, for the record, was the wish of the subject matter experts for this bylaw. The subject matter experts for the TA bylaw are the TA and the select board. And that was their desire, so be it. Other questions about the town administrator? Moving on. The Board of Public Works, which as I have already said, is a separate body from the select board that has its own duties and responsibilities. Excuse me, the current bylaw says that the Board of Public Works is responsible for the town properties and then gives a list that is horribly incomplete. So we changed it to say that the Board of Public Works is responsible for the town properties and is responsible for maintenance of town buildings. This next bullet has always proved problematic because some people want more detail and it's very difficult to coalesce. There are historically, in Mass General Law, there are road commissioners who are responsible for roads, and water commissioners responsible for public water, and sewer commissioners responsible for public sewer, and I forget all of the different commissions. The sections of Mass General Law that say that create the Board of Public Works that the town adopted in 1974. Does away with all of those. But all of those duties fall into the Board of Public Works. And trying to list those duties out is problematic, because just finding them scattered throughout Mass General Law is a problem. So we don't try to list them out. We just say, if it's a duty ascribed to a road commissioner, it goes to the Board of Public Works. Duty for water commissioners and sewer commissioners, they're all the responsibility of the Board of Public Works. Current bylaw says that, if I remember correctly, that the Board of Public Works is responsible for the operation of the town dumps. Well, we don't have any town dumps that are in operation today. We changed the language a little bit to make it clear that an operating town dump that is receiving materials, that's the responsibility of the Board of Public Works, with a certain amount of oversight by law by the Board of Health. But if it's a closed and capped landfill, that's entirely under the scope of the Board of Health, because that's the way the law is written. Relatively new bylaw, stormwater. We are putting the authority for all stormwater under the Board of Public Works because, in the end of the day, stormwater is a public work in the same way that water and sewer are a public work. They're just distributed differently in the town. The bylaw says explicitly, you will appoint you, the Board of Public Works, shall appoint a superintendent of public works. Why do we call it a superintendent? Because that's what Mass General Law calls that position. We have squishy language that allows it to be named something different because Joe Buckley did not want to be called a superintendent. He wanted to be called a director. Why? I don't know. I don't care. I will always refer to as superintendent because that's Mass General Law. So the bylaws always talk about superintendent. And then also, the Board of Public Works need to appoint a tree warden. The tree warden is important in other bylaws. That's what the Board of Public Works does. End of chapter 2. Chapter 3, financial affairs. How we deal with money. Current bylaw is called accounting/collecting and deals with both accounting processes and tax collecting processes. And we thought, that's not a good idea. We have two offices. We have the treasurer collector and we have the accountant. They have different duties and different processes. So we split the bylaw in two. One for the treasurer collector, and we're describing the office of treasurer collector, and one, for the accountant, for the office of the town accountant. In terms of the treasurer collector, most of the changes are structural. Because they're structural, they are substantive, but they do not change the effect of the law, so they aren't consequential. We added certain specific duties from the job description, because the treasurer collector asked us to do that. It's like, okay, sure. There were a few duties of other town officers in there. That town officers will feed receipts or bills to the treasurer and the accountant to be paid. Those don't belong in either of those bylaws because those are not duties of either the accountant or the treasurer collector. The accountant figures out the books, the treasurer collector receives and pays. So we moved those elsewhere. In fact, most of that needs to go into a new policy of the select board. Select board needs to write several policies based on our changes. But that's okay. Policies are easy. They're not that hard to write. They're not that hard to enact. And the new accountant bylaw is substantially the same as the accountant pieces of the current bylaw. Moving on to the Finance Committee. You will see this first sentence a lot. Remember that we have that appointed committees bylaw. So if it's covered in the appointed committee's bylaw and it's not special here, then it's removed. All the membership stuff that's covered elsewhere. Now, appointment is always, with a small asterisk, always done by the town moderator, which is a change from what we do today. Today, the town moderator appoints for the year that's coming up, actually for the seats that are empty on the Finance Committee for those terms. And then those are ratified by the Select Board. We broadened it so that the town moderator, well, actually, back up. If a vacancy occurs on Finance Committee, today, the Finance Committee can by itself appoint a new member to replace, or up until the next appointment cycle. Based on town council's feedback, the town moderator appoints under all conditions. Unless the town moderator isn't available or isn't able to appoint, in that case, the Finance Committee can appoint its own replacement. But every appointment, whether by the committee itself or by the moderator, is ratified by the Select Board. So the Select Board basically has always had a veto power. So that is the same as it is today. It's just that now all the appointment processes go through this ratification process. We made a few words to clarify ratification. Basically, the Select Board has to, at its next regular meeting following the appointment, make a decision to ratify. And if they don't decide to ratify, they have constructively ratified. Today, the appointment term is from the end of town meeting until the next town meeting. Well, if it's a 3-year term, then for 3 more town meetings. This has been changed to align with all the other appointments which are fiscal year based. So the appointments don't start at town meeting, they start the 1st of July.
That's
and
expensive.
It's mine, what do you care?
Because eventually you're gonna come and ask.
I have no idea what you mean. Yeah, if you didn't throw it around so much, I know, that's what I know. All right. So appointments begin 1st of July and run through the end of the appropriate fiscal year. By law, the Finance Committee is an advisory board on the budget. So there are words in the bylaw, proposed bylaw, that reinforce the advisory role. But even by law, and so we put it in here as well for stress, the Finance Committee submits the budget to town meeting. Also by law, Mass General Law, the Finance Committee has the ability and the authority to transfer money from the reserve fund. And we put it here to have a complete list of duties. We thought that it was best to put it here as well instead of having to dig through Mass General Law to find that stuff. Because the appointment of Finance Committee is different, we still wanted we, the committee, believe it is best to also still have the removal authority, especially for the 5 absences problem. So what we said was the removal of a finance committee member is done by a body consisting of the town moderator plus the select board. Now, that's a 6-member body today, which means it's possible to tie. You have 3 for and 3 against. And if that happens, then the person's not removed. But it's also our opinion that if it's not clear cut that a member needs to be removed, enough to get a majority, maybe that member shouldn't be removed.
So one thing that's not listed here as clear, in the past, good number of years, it's always been the finance committee that has jumped in and helped balance the budget. You can at least look back over the last 3 years and see who balances the budget. Currently, that change will now make the finance committee an advisory committee. If the town administrator does not do a balanced budget, it will fall upon the select board to complete that duty. Which, yes, they can delegate the responsibility, but I ask all of you to look to see in the last 3 years when the town administrator didn't provide a town balanced budget, who came up with that balanced budget?
Well, I'm actually going to broaden what you say just a little bit, and I'm not discounting anything you say at all. The town administrator is always responsible to the select board because the select board does the hiring. Which means that all of the duties of the town administrator are duties of the select board. You could consider it wouldn't be quite right, but you could consider it that every power of the town administrator is a delegation of the select board. And it's now, to Karen's point, she's exactly right, that there have been a number of years, not just the last 3,
No,
when.
but I'm just going back the last 3.
Well, the last 3 are important for a town administrator involved, but even before then, even before we had a town administrator, it was common practice in the town to cede budgeting authority to the finance committee by the select board. Even if it was never written down, it's what happened. Yep. There does always need to be somebody responsible. And
And currently,
it falls to the town administrator with the proposed bylaw, which would back up to the select board if the TA does not meet that responsibility.
finance committee members are the only members of any board in the entire town that cannot sit on any other board. The purpose of that is to keep us impartial because of our budgetary responsibilities. They are still, whereas we can have selectmen that are heads of CIPC and all other things. But that's the only thing that, the whole purpose was, when you sit on the finance committee, that's the only board you can sit on. Because you're supposed to be impartial for your budgetary needs. Now we're gonna be advisory.
Right, so it does beg the question, and you've brought this up at a
I have.
previous meeting, should that change?
Bringing it up on the 15th.
Yep. And I'm gonna go back and beg off by saying, what did we say we were gonna do? We're gonna document how the town behaves, not how should the town behave. So,
Yeah, but currently the select board does not bring the budget to the town. It is the finance committee. If we're going through.
and that's by law, because by law, the FinCom submits it to
In
them.
practice, it is the 7 members of the finance committee that are fighting through figuring out places to find structural deficits than the select board. And I would ask anyone to watch the last 3 years' worth of finance committees to see who's the ones coming up. Because it's not a joint effort. It has been, in the last 3 years, left
Far too
to the
much has been
finance
left to the
committee,
finance
has been left to have to make some very hard, horrible decisions.
Yeah, and in fact, there are words in the law that say that it's the town administrator's responsibility, not just to generate the budget, to generate a balanced budget.
Well, the first year of one of them,
Yep.
he said that was it. I've done everything, and left it in our lap. The second year, he was let go before it was finalized.
Which left the interim, who had his own,
Well, no, the interim wasn't even back in time for that. And then
right.
because at the time that he was let go, we were too close. It was what, 3 weeks of town meeting, I think? I want to say it was the beginning of April. And then we had the interim last year who there was much ado.
Other questions or comments about finance committee? CIPC. A lot of the changes. I pointed out a big one where the one that moved from CIPC to town meeting. There are other ones that are moved throughout. Because CIPC is in its current form, just describes duties of other boards or department heads. A very big philosophical change, which came from discussions with CIPC, NTA, and Select Board, is the CIPC does not generate a capital budget, it generates a plan. Here's my suggestion for what you should spend, what you, Mr. TA, should spend money on this year for capital projects. And it's up to the TA. The TA owns the capital budget in the same way that he owns the operating budget. I'm not sure I personally entirely agree with this next bullet item, but it's the way it was written, so be it, which is that anybody who wants a capital request from the town has to go through the town administrator. And in a way that makes sense because the TA owns the budget, but you need it in the plan, and how you get it to the plan when going through an extra step, whatever.
And how are you sure that the town administrator is gonna pass it to the CIPC?
That's right. I've already talked about the no appropriation shall be voted, fine.
Except if it's a citizen's petition.
Well, that's true, and those don't even flow through the TA directly either. So the CIPC creates its plan for how money should be spent, but it only does that once a year. Something happens. We have yet another problem at the water tower. We have another, what's that?
The water plant.
Yeah, anything at the water plant. That's always capital. And it's always an emergency, virtually always an emergency. CIPC is still supposed to consider every capital change, even something that comes up relatively suddenly. And those are done by a vote of extraordinary circumstances. And if the circumstances are deemed to be extraordinary, then it can be added to the plan and they can consider it. Whether or not something is extraordinary in today's bylaw must be by unanimous vote of CIPC. And with discussion with CIPC, that's been changed to be 2/3 vote. Still a supermajority, but it doesn't need to be unanimous. The current bylaw talks about the CIPC preparing warrant articles. Doesn't happen. I don't know that's ever happened. They're not responsible for warrant articles. And those are the consequential changes to CIPC. Questions on that? Revolving funds, I've already said this, that was amended on May 6th this past year. We have no further changes to make. We're moving on. Chapter 4, legal affairs. Legal affairs is as a chapter is a little bimodal, I'll call it. So the first thing it has is legal affairs bylaw, we'll talk about it, but the rest of it are bylaws that we couldn't find another place that all had to do with what I call punishing bad behavior. And that was the best grouping we could find of, rather than having a legal affairs chapter with nothing more than town council in it. So what is today called legal affairs is going to be called town council, and it describes the office of town council, which is an appointed position of the select board. Actually, that's this former, and I believe it. All the contents that were in that got moved in the select board bylaw because they were all duties of the select board. But we added the duties of town council, so that's what this bylaw now does. It describes the town council's office. All their duties, which is act on behalf of the town, do reviews. Town council is who we use when we get sued. Town council is who we use when we want to sue somebody. If we want legal counsel when we're talking to the state legislature, we use town council. Things like that. Contact with town, I'll say this first. Contact with town council flows through the town administrator. As with everything else, there are always these little asterisks. And if you read the law, the bylaw, unless direct access is allowed by some other law. So if, for a while, in fact, the current bylaw committee bylaw says that the committee may directly talk to council. Because the bylaw committee frequently needs to talk to council to talk about the legality of anything, to do bylaw review, all of that. So if there's a provision that allows direct access to council, they can go through it. But if there is no direct access, everybody has to go through town council or the select board. Now, that's not written here, but it's still true. You can always ask the TA, and if he says no, you go to the select board and ask them as a body.
So zoning board of appeals needs to contact a lawyer to discuss a cell tower. Let's just throw that out there.
Sure.
And town administrator says, no, you don't have any funds, you can't spend the money. And we're just gonna, then somebody from the zoning board of appeals has to take it upon themselves to come to a board of selectmen meeting to then go over the TA's head.
Fast answer, yes.
But luckily, a good portion of our zoning board are attorneys.
Yeah,
I know.
but still, I mean, it's, that could change at any time, and the thing is, you know, I'm thinking of the times when any one of the boards, the Conservation Commission might need to contact so now they have to go through the town administrator says no, it holds up everything versus just going direct. I understand if you don't have the funds to pay for it, that's very different. If you don't have a budget line or a way to pay for it, I totally get it. But if you have a budget line to pay for it and or a revolving fund that is meant to pay for those kinds of things, it's kind of like, because now it can be holding up something for 3 or 4 days, maybe a week if they're on vacation.
And
that kind of
everything they're involved with is timing too, so.
Right. And that's, I mean, between that and then the next one is, yeah.
Same with the planning board, you know. I feel that we don't have to go through town administrator or select board, we go directly right to town council. On,
If you don't have an authority in law, then you're not allowed to. If there is an authority
even
in
though
law,
we have our fund set up, for that, and then subdivisions, rules and regulations, there's legal fees
Yep.
tucked in there,
sure is.
and we're elected board. We don't have the right to go to the town council, we get our own council.
That's special counsel. Using anyone other than town council is using special counsel.
Even if they're free.
Even if they're free, you're not allowed to use special counsel without permission of the TA or select board.
That's not good. That is not good. Even the moderator for crying out loud, that one time with the town council on, Ag Commission, and she said it was wrong and all that, but she was wrong. And she wanted to try to get in touch with the Ag Commission, to sit down with them, to try to go over and find out, but never did. And I feel the planning board, being elected, I feel that that's, time, gotta go through TA, select board.
I mean, as a practical matter, when is the TA going to say no? Now, there's nothing in law that says when, but as a practical matter, when is the TA gonna say no? TA will say no if you don't have budget, or at least has the authority to say no if you don't have a budget, and the town's already exhausted its legal fund for the year, which happens shockingly early. If the question's already been asked, and if the TA is copied on everything, the TA already knows the answer. So we can give the previous opinion on a question. As opposed to, how many times have I said this? If town council's reading an email, town council's on the clock. Town clock, make a phone call to town council, on the clock, from
That's
the
any
moment they
attorney.
pick up the phone.
That's any attorney,
That's right.
whether
Oh,
it
yeah,
be town
but-
council or not, that's
Yeah.
any attorney.
It is, it's the way it goes. So passing a question off to town council always has a cost associated with it, whether we like it or not.
Now,
I'm not saying it's the best way, I'm saying it's the way that's been settled on.
now our TA right now has been with us a year. He's not gonna have access to every legal thing that's been asked in the last two town administrators, easily. I mean, yes, he has access, but it's not easily accessible.
Do not have the knowledge to answer that question. I don't know how easy it is for that. I know the information is there because I know he has all the emails. How easy is it to find what he's looking for? I can't answer that. Anything else on town council? License and permits of delinquent taxpayers, a bylaw that's on the books today that says that if you owe taxes, that any licensing authority in town can either deny your request for a permit or revoke your permit. That's all it says. Only making inconsequential changes. Ooh, I bet I should have changed this one. Let's find out. No, that's about right. We have a current public drinking bylaw that's been extended to include consumption of substances containing, well, let's just say, let's broaden that. Consumption of marijuana. And the changes, without going through it in gross detail, everything that's illegal to do in public drinking is illegal to do in public with marijuana. Except if you're on private property, there are no marijuana restrictions. So if you're on public property, marijuana and alcohol have the same level of legality for consumption.
Is that just through smoking the THC, or is it through
Nope.
edibles?
And edibles as well. I know Karen's dying to say something about Memorial Field during many of our,
Just saying, you know, July 4th, Friday night concerts on the Common. I'm telling you, $100 a whack, we could pay off the budget deficit in 1 year. Poof. $100 a whack.
or is that puff?
But
And the police department could delegate authority to go after him to the finance committee.
no, that's not correct.
Unfortunately, no.
I wish they'd let me. But
I'd help you out.
because we definitely look the other way on certain events, that we don't look the other way on other events.
So, let's talk about that in a little more detail. There is a specific provision in the current bylaw that's being carried over into the new bylaw that says that these restrictions do not apply to any event duly licensed by the select board in accordance with law. That's why you're allowed to drink on Memorial Field during any of the 300 celebrations, because all those beer and wine cellars were licensed by the select board. But there is no provision in Mass General Law today to duly license public consumption of marijuana and its products. But I can see a point where that might happen in the future.
How many people on Memorial Field during July 3rd and 4th
Yep.
bring their own consumptible? They don't
Their own
always go through
consumables,
the,
absolutely.
they don't always go through the appropriate sellers.
Yep. Unregistered motor vehicles, current bylaw that says you can have 2 vehicles unregistered or parts of them on your property, and more than that is a violation of the law. That's moving forward. No consequential changes to that one either. Excuse me, you can have them on your property, not in an enclosure, not in a building. If it's in a building, it doesn't matter, but if they're out for all to see, apparently that is objectionable. And that is the end of chapter 4.
That's up to the police?
Yes,
Do they have to have a, what the heck do you call it?
Complaint.
Complaint in order to do anything, or can they do it automatic?
they can do it themselves, as long as it can be seen from the public way. Because if they have to enter the property, then they have to enter private property, and you're not allowed to do that without cause. A police officer can't just enter a property
Has to be a reason.
for enforcement purposes. If from the road they can see 3 vehicle carcasses, unless it's a farm vehicle, that's an exception, that's an exception today, it'll be an exception in the future. Farming is a really interesting thing, agriculture as a whole, because Mass General Law has a lot of exceptions from other laws for agricultural activities. This is just one of them. There are, for example, the Conservation Commission, its Wetlands Protection Act has lots of exceptions for agricultural activities in the laws. It's just one of those things. So this is just another place where farm vehicles, or I think we said vehicles used in farming. Questions on anything we've talked about today, because I'm gonna end early if we're done. This was the exact spot where we stopped the first time through. I think I've dulled your brains enough for one day. I applaud everyone who didn't snore once.
No, I appreciate it. It really helped me understand more about governing a smaller town with a town meeting form of government.
So, we will continue this.
Good job, Peter.
Thank you. We will continue this next week. The plan is to finish this cycle of review next week, which will look a lot like last week. And I hope to see everyone at town meeting on the 15th of February.
Motion to adjourn? Did you want to say more?
We never opened.
Oh, we didn't open.
We
Lynn
never
just
opened,
came,
even when
that's
Lynn was
right.
here. Linda,
But I've
we
been
didn't
taking
discuss any.
notes.
Oh, okay.
No, I'm kidding.
Yeah. All right. I think we are.
That's
I
true.
hope I didn't miss Sherry. No, I did not miss Sherry. She never found.
She wasn't sure.
She
when
might go in and watch it on
Ah.
public TV.
Yeah. All right. Thank you, everyone. I appreciate you being here.
Thank you.